First of all, it's great to see everybody. Again, I feel like I spoke with many of you yesterday on the presidential primary date. I'm here today to make an announcement about the appeal in the Amendment 6 litigation going on in federal court down in Miami, where the trial court ruled. Obviously, that litigation involves a constitutional question and how to resolve it regarding the responsibility of the Florida legislature under the United States Constitution, the state constitution, the Federal Voting Rights Act, and the case law. And while I respect the trial court's attempt to answer that question, I think the trial judge reached a conclusion that is not only inconsistent with the federal constitution, specifically Section 1, Article 4, but also the case law. And frankly, it also included some factual inaccuracies that reflect a basic misapprehension of some key facts. So I've directed our counsel to appeal that trial court ruling. I think we have a strong legal argument, and I'm hopeful that the 11th Circuit agrees. I think it's important to note at the outset that this lawsuit is not about any specific map or even this specific year. It's about defining the responsibility of our state legislature under the federal constitution, which may last decades beyond this one. It's also important to note that this appeal will not affect in any way the ongoing map drawing process that we in the House and our partners in the Senate have been engaging in. I know that Chair Weatherford and Chair Gates have done an outstanding job, I believe, of seeking public input, and this has frankly been the most publicly participatory process, reapportionment process in the history of our state. But we do have an obligation. I took an oath, as did our judges, to uphold both the federal constitution and the state constitution. And we've got an obligation to, and we'll fully carry that out, to comply with all of the language in the Florida Constitution, the U.S. Constitution, and the federal VRA. But we are going to seek clarification about what those duties are from the federal courts. And I'll be glad to take any questions on that or anything else.
If it's a clarification, and that was something that was said again and again on the redistricting tour this summer, why not take the court's clarification of it? I mean, aren't you at this point adversarial to the amendment?
Well, we're adversarial to the amendment in the sense that just like years ago in the term limits case, the voters of Florida put into the Florida Constitution an 8-year term limit. And when the voters voted on it, it said this 8-year term limit will apply to the State House and Senate seats, and it will apply to the congressional seats. The federal court said, no, it doesn't apply to the congressional seats because Article 1, Section 4 of the U.S. Constitution says only Congress and the Constitution, federal Constitution, can prescribe limits like that. And we think the exact same argument applies here. So in that sense, we are adversarial on the issue of whether the language of what was Amendment 6 and is now in the Florida Constitution can actually be consistently interpreted with the federal Constitution. But by the same token, I've directed Chair Weatherford, and I know Chairman Gates are doing the same thing, that we intend to draw maps that fully comply with the language of Amendments 5 and 6, because, frankly, both as a matter of our goal and as a matter of pragmatics, we're going to do everything we can to make sure our maps meet the full requirements of Amendments 5 and 6, because it's unlikely that the court would even rule on this until probably after the fact.
But you're not seeking clarification anymore. You're seeking for the amendment to be thrown out, essentially.
Well, yes, but we're seeking clarification that the language of Amendment 6 does not apply to congressional districts, i.e., just like in the U.S. term limits versus Thornton case, that the state constitution cannot preempt the federal constitution. I thought of an analogy this morning. If a group called fairpress.org put something on the ballot in Florida that said reporters could be sued for misstating facts in an article and be held personally liable, I bet, number one, 60% of the people would vote for it. And number two, I bet that a federal court would find that that was inconsistent with the freedom of the press guaranteed to us in our U.S. Constitution. I speculate that every editorial board in the state would say the federal Constitution can't undercut the freedom of the press guaranteed to our citizens and our country by the U.S. Constitution. Same principle applies here.
Will Congresswoman Brown and Congressman Diaz-Balart be joining you in this appeal?
Well, yes, actually, I think they're appealing, and we would be joining them. I think it's sort of we would both be appealing, but my understanding is that they intend to appeal, and we intend to join with them, just as we did at the trial court level.
And can you clarify something? There are other states that impose standards and rules on redistricting that apply to congressional districts. If this is overturned by the court here, do you think it will have application potentially for all those other states that also apply their own rules?
It might. Here's the problem. There are some inconsistencies in the federal case law and changes over time. If you take the trial court's order at face value, arguably Alabama in the 60s could have disregarded the Federal Voting Rights Act because they could have made that same argument. And so if you read the cases, like in most case law, there are potential contradictions and maybe different approaches to issues at different time. My job as the Speaker of this House and a Florida constitutional officer is to get an answer to that question as best we can for Florida under these circumstances. Because 10 years from now, another legislature is going to have to reapportion our seats, and getting those questions answered with as much precision as possible, I think, is important, and that's what we're all about.
One of the most criticisms during the hearings that were held this summer was that taxpayer money was being used to participate in this lawsuit against what voters had passed back in November. What do you say to those people?
Let me tell you what taxpayer money's done so far. We've had more public participation and more input in this redistricting than ever by a huge factor. I know that all the members of the redistricting committees have had hearings around the state. We've had 5,000 people in attendance at the hearings. Here's an interesting statistic. Back in the last redistricting from 2000 to 2002, 4 maps were submitted by members of the public. So far to date, because we've used our My District Builder software, we've had 71 maps submitted. With our software we've made available to literally anyone in the world with an internet connection, we've had, there was a 13-year-old from Tampa who drew 2 complete 120 district maps. I think what's most telling is that the proponents of not filing this appeal have utterly refused to submit any maps, which I think reveals their lack of good faith in this process. They say, oh, don't spend money on it, but they haven't availed themselves of the public hearings where they could have input. It says to me that what they really are all about is getting the political boundaries ultimately drawn by unelected judges. We've got a 200-year tradition in this country that judges don't make political decisions. And it's an unfortunate trend in this country and in this state that folks that are unsuccessful pushing their agenda in the representative democracy that our Constitution calls for try to resort to the courts to go around that. And I think the fact that fairdistricts.org and the other entities who are suggesting that we shouldn't appeal are saying you just shouldn't appeal, you shouldn't even ask the question, that rings a little hollow when they won't even participate after chiding us for engaging what I think, again, is one of the most open and publicly participatory processes in the history of the state.
Now, you're not asking for an accelerated ruling by a court.
I don't think so. Again, I think it's more about we're going to continue the process. The process, and again, my hat is off to Chairman Gates and Chairman Weatherford and all the members of those committees. They've done a lot of hard work, and I think that the citizens of the state should be very proud. This appeal is not about altering the process which we are already following and which remains unchanged, which is to get the maximal public input, the maximal degree of public participation, the maximum accessibility both to citizens, to observers, and to the press of whose ideas they have out here. And again, I think if Fair Districts wants to be seen as anything but a left-wing special interest group, they should propose maps instead of bashing the game because they don't like the score. And so it won't change that process at all. This is about, in this country, the rule of law and clarity on elections law. We all harken back to 2000. What's a hanging chad? Is it a vote or isn't it? We need to get those questions answered before we get in to the 12 cycle, or more importantly, until they try the reapportionment process again in 20 to 2022. We're going to follow the language of Amendments 5 and 6 as we go through this process, just like Chairman Gates and Chairman Weatherford have been doing. We're going to continue that all the way through the end.
If you get to the point that you've drawn maps in accordance with Amendments 5 and 6, at least you feel that way, if you get a ruling in your favor from an appeals court, do you go back and start redrawing Amendment 6 maps?
I don't think so at all.
Without Amendment 6?
No, I don't think so at all.
Can you respond to some of the criticism of the decision on setting the January 31st primary? You've had people within your own party leadership even saying that this is going to lead to a brokered convention, the idea that you're going to lose half your delegates, and so those final group is going to be splintered, and this will hurt Florida in the end. What do you say to that?
I think, number one, that's just utterly not untrue, and you have to look no further than the last presidential election in 2008 to prove that that's not true. Guess what the presidential primary date was in 2008? January 31st. We went 5th. Everybody said the same thing. Oh my gosh, you might lose the seating of half of your delegates at a convention, which, by the way, is going to be held in Tampa. I think most of the people saying those things are people who might not have their seat on the floor, and that's probably what they may be more worried about. Florida is the most economically, demographically, and geographically diverse state in the country. From an issue standpoint, we're diverse as well. And we also, by far and away, are the largest electoral state that's up for grabs. With 29 electoral votes, Florida has more votes than Iowa, New Hampshire, Nevada, and South Carolina combined. And we proved back in 2008 that the person that won Florida became the Republican Party's nominee. And I think that it maximizes Floridians' voters' voices. It may cause some heartburn among people who want to go sit in a certain seat at the convention. But I think historically we've got both a compositional argument and now the historical argument that Florida belongs 5th. And I want to say this to be very clear. We have no intention, and one of the reasons we picked January 31st is because we have no intention of trying to precede Iowa, New Hampshire, Nevada, and South Carolina. This is what happened in 2008. Our hope would be that they would follow a very similar to schedule to what we did in 2008, so that those traditional early primary states, we could honor that tradition and respect their ability to do that. But that once, I think Arizona was the first state to break the RNC rules a couple of weeks ago. My job is to protect Florida voters and Floridians first and worry about RNC rules second.
Do you think that the message coming out of Florida, if it's the January 31st date, is not as powerful because now you lose your winner-take-all, provision? You become proportionately distributed to those delegates.
I don't think so. Again, I think that the nominee will be chosen long before the convention. That's what happened in 2008. That's what's going to happen again. And again, these same arguments that are, the sky is going to fall and terrible things are going to happen, none of that came to pass. And again, I think Florida maintains our maximal voice in that national conversation by going 5th and by going on January 31st. And so I think that, again, I feel comfortable in that. And my hope, frankly, would be that the RNC would realize, if it plays out that way again, that they might relook at that rule and consider placing Florida 5th as a more matter of course, both because of our issue diversity, our economic diversity, our ethnic diversity, and our large size.
Speaker could also, he brought up he suggested, as I'm sure you know, that Florida will have little, if any, impact this way because of the few delegates.
How much impact did we have in 2008?
Would get. He also suggested that there might be some embarrassment at the convention. He suggested Sharon Day and I will now be embarrassed for our state as we host the convention from the back row and have a hotel 30 to 40 miles away with few guest passes.
Look, if he's worried about his commute from the hotel, then he's clearly not focused on what's most important, which is maximizing Florida's voters' voices in this process. I have great respect for Chairman Senf and Chairwoman Day, but again, my job is to look out for Floridians first and worry about party rules and where people sit and where people stay in what hotel at conventions secondarily to that.
What about the threats about? Are you comfortable with the way the prison privatization plans went down? The PBA, they're challenging that in circuit court right now.
It's funny. First of all, it's not surprising me that a union would oppose privatization. That's pretty run-of-the-mill. I'm not really familiar with their arguments. I think we have an obligation to do what's best for Floridians, whether that's on the fiscal side, the policy side. I feel very comfortable about the substance of that bill, and again, they'll have their day in court. See what the courts say about it.
Back on fair districts, if we could for a minute.
Let me get him.
You passed it, to follow up on that question, you passed that prison privatization apparently without any sort of business justification for how it would work.
Last I read here, we passed a lot of things. I don't think business plans are part of what we do to make public policy.
We've got time for one more.
What about the concern among some in the party about moving the primary up that'll essentially help Mitt Romney, another moderate, claim the nomination? Is that a legitimate concern? Do you think that'll pan out?
That, again, totally is not my concern. I hope it would help or harm all of the candidates equally. I happen to have chosen a candidate that I'm proud to endorse in that race, and it may disadvantage him or her. I really don't care. My job is, again, look out for Floridians first and do what maximizes Florida's voters' impact. And again, I would hope, and I think it's been reflected in the behavior of the candidates, that they're all taking Florida very seriously. Something tells me that if we go on January 31st, they won't take us any less seriously, because one could probably argue that those that skipped it last time regretted it. one more.
Back on Amendment 6 for a minute. Your lawyers have essentially argued in court that the people of Florida can't tell the legislature how to draw the congressional lines. Do you agree
No,
with that?
No, that's not an accurate characterization. What they've argued is that the people of Florida can't rewrite on their own the U.S. Constitution. Again, if we in Florida said we want to abolish the right to freedom of religion in this state, that would be, even if 60% of the people passed it. You know, we've heard these arguments about Sharia law. What if a constitutional amendment were passed that abridged the freedom of the press or the freedom of religion? It would get challenged, and the holding would be, hey, even though 60% of the people in Florida may feel this way, you can't abridge some of these basic constitutional provisions that are explicit and express and very unambiguous in the U.S. Constitution. And that's true whether it's about reapportionment, freedom of the press, freedom of religion, et cetera. And that, I think, is a right view of it. You know, as a person who believes strongly in limited government, and that in the federal Constitution it enumerates certain powers, it spells it out, those words have meaning, and if it doesn't give those powers, they're not there. That's exactly what this lawsuit is about. Listen, it's good to see you guys. Welcome back. We'll see you soon.